I have known Susan Katzen for at least 10 years, and I know that because that's the date of my son's special needs trust. It's June of 2010. And, you know, we did a special needs trust for a lot of different reasons. The first was to have a plan for our son if at some point we don't exist anymore, and we wanted him to have, you know, a safety net for when that eventuality happens. Another reason why we ended up doing it when we did it, Josh is 28, he was 18 at the time. And the reason was Susan's going to go into a number of the benefit programs, but some of those are based on needs. And a special needs trust is a way to move some of the assets that your child might have accumulated into a structure that is not counted by the government. So one of the things is for Social Security, you can't have, SSI, you can't have $2,000, more than $2,000 in your bank account. Well, my son had a bar mitzvah, so he had a little bit more money. And so we were able to move that money in under one of the special needs trusts that Susan set up. And then the third benefit that we got, which we didn't realize at the time, but one of the things that we did when we worked with Susan is she had us have a letter to send to family members who might leave money to our child. And so we sent this letter to my parents, and we sent it to my mother, you know, my mother-in-law, and we sent it to my cousin, or to my sister-in-law, Betsy. And you know, we were hoping that if they were leaving money that they would update it so that they left money to the trust instead of to Josh. Well, as it turns out, Betsy's no longer with us. She had, 5 years ago, she passed away from non-Hodgkin's lymphoma. And she had changed her 401k and her life insurance policy to leave the money rather than to Josh, but to Josh's trust. And so there was no disruption, and I think it ended up prompting her to do that. I don't think she had set it up that way, but I think getting the note from Susan prompted her. And that it's been a big loss losing Betsy, but she had no husband or kids or anything, and having her have left, and she was always very close to Josh, and having her have left that money to Josh really helped fund his college and allowed him to live in the dorm and gave him some money that would have enabled us to retire because we didn't have to pay for everything ourselves. So you don't know when you're going to pass away, and you don't know when your relatives are going to pass away. She died at 63. That was very young, but it's going to happen, unfortunately, and it's good to have a plan. And I trust Susan, and I know she'll do a good job explaining this to all of you. So I'm really happy to introduce Susan Katzen and her assistant, her co-attorney, Nena Sheldon. Nena's going to be sharing the slides. They sent over copies of the presentations and copies of a handout about ABLE accounts. And I emailed that out to you guys before, but there are links in the chat session, so you can click on those and print those if you'd like. And I'm done. So with that, I'll probably be back later to ask questions of Susan, but with that, welcome, Susan. Glad to see you in our virtual world here.
Thank you. Thank you. Thank you for having me here tonight. So Judy mentioned planning, and I think, we always talk about it, and sometimes it just isn't the thing that's probably on the front of our list of things to take care of. However, I think with COVID, we've seen the importance of planning, as well as the importance, if you have done planning, of reviewing your documents and making sure that they are up to date. So there is nothing really magical about planning. Planning is really about providing avenues of social and recreational educational activities that enhance your child's quality of life, as well as, you know, providing financial security for them. So when you look at this, let's break it down into a couple of key areas. So you're going to want to look at government benefits. Sometimes they're going to, is that Medi-Cal is almost always important, and SSI, or supplemental security income, is like the icing on the cake. So you're going to want to understand public benefits and figure out where they are in your planning process. You're also going to want to look at how do you envision your child's future while you're alive, as well as when you maybe are either incapacitated or deceased. What do you want for your child? And then you're going to take a look at using trust to go ahead and accomplish some of these goals. Because as Judy said, a trust is probably the best way, if not the only way, to go ahead and protect their needs-based government benefits. And it also protects them from undue influence and from being taken advantage of, and provides advocacy for them, which is really what you're looking for. So I'm not able to see, Nena, do you have the slides up?
Yes, I do.
So let's see. Why am I not able to see your screen? I see you. Are you sharing your screen?
Yeah, Judy, do you have, did you put it back to our screen to share?
Well, we'll go on to the next one. To flip to the, flip to the next slide, which is public benefits. So the reason that you need to go ahead and think about—
Hold on a second, Nena. I don't think you're sharing.
So there's a little green button in the middle of your screen at the bottom that says share screen.
Yes, okay.
There you go.
There we go.
Thank
Perfect.
you.
Thank you. Thank you. Yep. Slide 2. Very good. Thank you very much. So the reality is most individuals with disabilities at some point in time are going to end up having to access government benefits in some shape or form. So it's important for you to understand the difference. So what we've created is a slide that— what happened to the slide? It's a slide that shows you the different public benefits that are available.
One second. For some reason, it says Carrie Purdue is sharing. So Carrie needs to not be sharing. And Nena, you may need to share again.
So, okay, so when you look at the benefits, the two main types of benefits that we're going to be looking at are means tested or needs-based government benefits, which are going to be supplemental security income, otherwise known as SSI, and Medi-Cal. And then for entitlement-based benefits, the reason you have entitlement-based benefits is because you paid something into the system or you achieved a certain age. And those are going to be Social Security Disability Insurance, otherwise known as SSDI, and Medicare. And you know, you think of Medicare, it's with usually with the elderly, and there are a few exceptions to that. And then we've got the other benefits, which are not necessarily limited to individuals with disabilities, but in most cases they are only available in certain circumstances. And that's going to be Section 8 and Regional Center, which we really aren't going to touch on those today. We've got a lot of material to cover, so we want to make sure that we go through as much as we can in the short period in time. So next slide, please. And so when you look at SSI, which is probably one of the common ones if your child has reached the age of 18 that you're going to be attempting to access, you're going to look at what does it do. And SSI is a cash program that provides for food and shelter of the eligible recipient. Along with that, of course, you would expect that there are ties that come along with it. First one is the individual must be disabled under Social Security's definition of disability. For an adult child, that definition really encompasses being incapacitated for 12 months in a fashion that prevents you from being substantially gainfully employed. And when they talk about substantial gainful employment, they have actually quantified that, and that is a number that changes every year. But this year in 2020, it's $1,260 a month. So if you earn more than $1,260, you're not considered disabled anymore. Kind of odd, but you know, when you look at the rules in Social Security, you see that they really are a little bit quirky. And then they look at your income and your resources, and resources are capped at $2,000. And when you think of resources, think really of cash, because that's primarily what you are looking at: houses, cars, computers, personal property. Most of those items are exempt assets. And then income is another oddity with SSI. They have multiple different types of income. Each type of income that a recipient receives causes some reduction in their benefits. The most dramatic reduction comes from unearned income, which would be interest, royalties, SSDI, gifts, etc. When you have earned income, they're a little bit more liberal with you, but they do go ahead and count income. The best part of qualifying for SSI in California is that if you qualify for SSI, you automatically qualify for Medi-Cal. It is called being categorically eligible. And now that we're mentioning Medi-Cal, Medi-Cal is a health insurance program that is available to individuals that have low income, and again, the $2,000 resource limit, and it provides for your durable medical equipment, hospitalizations, medicines, pretty broad scope. And I think the biggest thing for many families is the fact that it provides for in-home support services and maybe potentially some long-term care in the future. Since we're all living longer nowadays, that is something that we do want to go ahead and consider. The other public benefit that we're going to look at is the entitlement-based benefits. And again, it's based on something that you've put into the system. You know, when you get your paycheck and they've taken out taxes, that's part of this entitlement program. So a child can qualify on their own if they have worked and if they've obtained enough work credits, and then they become disabled. And the work credits are actually based on the amount of money that you've earned per quarter, and then 4 quarters in a year, or 3 quarters in a year, right? Well, 4 quarters. So they go ahead and add those up, and as you age, the number of work credits that you have to have increases. So a young person could go ahead and qualify if they are disabled. So if they are disabled, they would be able to go ahead and receive this money, which is going to be a portion of what they did earn. Oftentimes it's not a significant amount, but it is better than nothing, and it doesn't come with any true income restriction other than the $1,260 for the substantial gainful employment. But more importantly, it doesn't have the resource restriction of the $2,000 as the limit of assets that they can have. One of the advantages with SSDI is that you can apply for Medicare after you've been eligible for SSDI for 24 months, which is great because it does go ahead and expand your physicians and eligibility to go see different hospitals and specialists. As well as a couple of things, you can be dual eligible, which would be SSI, SSDI, Medicare, and Medi-Cal. A couple of things you want to think about is if they are eligible for SSDI, Medicare, and Medi-Cal, Medi-Cal can go ahead and pick up the co-pays and the premiums on the Medicare policy. One of the downsides of being eligible for Medicare is that it does take you out of potential eligibility for any ACA Medi-Cal. Next, we would want to look at the child disability benefits. It used to be called disabled adult child, and this is when the child hasn't worked and they could qualify on your work credits. And so the key with that is that the child has to be disabled before age 22, never married or married and divorced, and then they will be able to collect on their parent's work record, provided their parent is retired, disabled, or deceased. And if they are retired or disabled, they will collect 50% of the amount, and it doesn't reduce the amount to the parent. It is just in addition to it. And 75% of the parental amount if the parent is deceased. Again, as I said before, SSDI is unearned income. So if you get a significant amount of SSDI, or the child gets a significant amount of SSDI based on the parent limit, they could lose their SSI and they would need to then qualify for a different type of Medi-Cal, but it wouldn't be lost and then you have nothing. So they do go ahead and transition into a different type of Medi-Cal. So once you've decided what place public benefits play in your child's life, you would want to go ahead and start thinking about your planning. You know, what are you looking for? Are you going to have enough assets that your child is not going to need to access government benefits? Are they going to have income coming from other sources? And then you want to start looking at protecting those. So a special needs trust is a great way to protect needs-based government benefits while at the same time providing for supplemental funds to pay for quality of life items for your child. So the assets held in the special needs trust do not go ahead and disqualify the beneficiary from public benefits because the assets are actually held by the trust and they're distributed for the benefit of the beneficiary based on the specific guidelines that you as the parent have set forth in the trust document. And this is really important because, again, you as the parent know better than anybody else what your child needs now and what your child is likely going to go ahead and need in the future. So far better than any judge, any regional center, service coordinator, because you're the parent, you've lived with them all of your life. So you want to think about what do you want to include inside of that trust. So you can customize your trust to put pretty much anything. You can cover housing. Are they going to drive? Do you want them to have a vehicle? Some people want to make sure that when we specify that the trust can purchase a vehicle, that we put that it can purchase a vehicle with a GPS on it because, you know, they get lost. They have a tendency to not be able to find where they need to go at any specific time, and so that's important to them. Some of them want them to have financial counseling, if they want them to have a companion animal. The sky is really the limit, and you're only limited by your own creativity. Now, this special needs trust can be created by a will. It can be created testamentary through a revocable living trust, or it can be created as a revocable living special needs trust, much like what a person would create to trust for themselves. And the advantage of having a revocable living special needs trust is other people can contribute to that trust during that child's lifetime. Two, you get to test it out. You wouldn't buy a pair of shoes. You wouldn't buy a car without trying it out. So you don't want to go ahead and leave this trust to, well, hopefully I'll go ahead and be well once I pass away. You want to really try it out so you can make any changes during your lifetime. And then you want to look at the people that you're going to have be there, you know, your so-called village. It does take a village in many cases to go ahead and provide the love, support, and advocacy that you did as parents, because nobody can do it as good as you. So you need those people to be in addition to the rules and guidelines that you've set forth to go ahead and assist. So think about trustee. Trustee is going to be the person, initially it'll be you, but it'll be the person that's going to go ahead and manage the assets and make distributions based on your recommendations and your guidelines set forth inside of the trust. They're going to protect your child from predators, predators and creditors, and oftentimes themselves. Don't forget to name a successor trustee. So you'd be first, you name your successors. Doesn't really cost more to name multiple people down the line, but the importance is, you know, have a good feeling, like those people, trust those people, and understand that they are sometimes going to have to say no to your child. I like to use a trust advisory committee and a trust protector because I'm all about checks and balances and making sure that that child has love all around them and people to go ahead and talk to and relate to if they need assistance. I mean, it's been, I sit on the board at Special Olympics, and it's been pretty scary for some of these kids not having that communication, and you really want them to go ahead and have people in their life that are there to give them guidance, that are there to go ahead and advocate for them, that are there to make sure that they're getting the proper medical care and anything else. So you can give trust protector authority to go ahead and make changes. The government benefits laws are always changing. Trust law changes. You can give it to the trust advisor, that same set of duties to the trust advisory committee. But the more people you have, the better. If you think that you don't have a village, we are really good at creating them, because there are so many people in your child's life that absolutely love and adore your child and are very honored when you ask them to participate, because it's not a big job. It's more a job of caring and compassion for somebody, not a lot of technical work. But it's good if you have it in advance so that you can test your document out and see. You can look at them with a straight face and tell them it's not that bad. So when you look at creating your plan, you really want to, as I said in the beginning, envision their future. What do you see for them? Where are they going to live? Are they going to have specific medical needs that are going to have to be addressed? Will they require a conservatorship, or can they go ahead and sign the basic planning documents that a person should have once they turn age 18? What people do you want involved in their life? Or your family? Do you have family that's on this coast? Are they on the East Coast? Do you want the trust advisory committee? Do you want a care manager, an advocate? And then how do you envision their lifestyle? You know, where do you see them living, and in what type of lifestyle? What kinds of things are they going to do? So once you go ahead and once you go ahead and create that lifestyle, you need to put it down on paper. And what we call that is creating your memorandum of intent. And it is such a critical document. Even if you don't have a trust in place, you should really take the time to put one of these together. And you can go ahead and call Joy or Stephen in my office, and we'll send you a sample one or a sample format on how to do it. But it is so critical. So families and the people that are in your circle know exactly what you want for your child, what your expectations and goals are. So a memorandum of intent should include ample information so that anyone that is going to be involved in your child's life in the future is going to be able to understand their strengths, their challenges, their needs, and their unique personality. You'll also want to go ahead and include ample details about the medical and rehabilitative needs, educational goals, work expectations, anything like that. Again, you have the opportunity while this is in existence, while you're alive, to make those changes. So as your child grows and develops, I mean, when I met Josh, he used to sit inside of my waiting room and he'd play on his, I don't know, his little electronic device. And I mean, I was absolutely thrilled and so proud when he went to school and in a dorm. So things change. I mean, he grew up and he's done well, now off to a job. I mean, what more could a parent ask for? And that's what you want to address in your memorandum of intent. You know, do you want your child to live with a sibling or with an aunt or with a friend or in their own house? Do they need assistance? All of those things. And keep in mind, a memorandum of intent is not a legally binding document, but it's the encyclopedia to your child. And it assists with any trustee having to understand what your intent is. And that's really important because this is all about what your intent is in meeting your goals and your expectations. Okay? So once you have created your memorandum of intent, you want to look at the lifestyle that you've envisioned and try and determine what the cost is and if you have adequate resources. So when you look at income, think about, are they going to get SSI? Will you be receiving SSD? I remember teachers don't get that. They have that pension plan, and when they pass, it does stop. So, you know, look at what additional sources of income they're going to have. Maybe it's going to be income from businesses or from investment accounts. And then take a look at the expenses. And you think about things like living, medical, transportation, care, clothing, social, all of those things. And then take your expenses from your income. And oftentimes what you're going to find is that there's going to be some type of shortfall. And that shortfall is the target that you want to shoot for to fund your trust with. You know, and that can be through your assets, you know, when you pass. It can be through an insurance policy, whatever works for your situation. But that gives you at least a starting point. So people will come in and say, how much do I put in? It's go through the numbers, and when we sit down and it's like, this is a life plan. And this is something that, you know, if you work on it yearly with yourself, your husband, your child, if they've got the capacity, you can really fine tune it to get some good numbers in place, good ideas in place, expectations and goals. So let's talk about ways to plan. It's important for parents to go ahead and have their own revocable living trust. You don't want to go through probate. During this COVID, the courts shut down. So everything that was on calendar is now a year later. Well, that's bad because everything that was already on calendar before they closed was 9 months down the road before you had a hearing. So you really want to take things in your hands make sure that you've got something in place you can deal with incapacity. Along with your living trust would come a will that identifies, again, who are going to be the people in charge when you can't do it. Most importantly, probably one of the biggest things that we saw with COVID was, healthcare power. You need to have somebody that can make healthcare decisions. Nena and I went to court over the last couple of weeks for emergency orders because people didn't have healthcare powers in place, and they ended up inside of facilities. Financial power, that will take care of things like Social Security, that will take care of your retirement plans, homeowners insurance, things that are outside of the trust. So you want to have something that coordinates with your trustee. Make sure you check your beneficiary designations now. People die, people get divorced, people don't talk to each other. You want to make sure that you've got the right beneficiary on policy, because if something happens to you, you become incapacitated or die, that beneficiary designation that you had, if it's to your ex-husband, is going to your ex-husband. Or if you have 3 kids and you only have 2 listed on it, it's going to go to the 2 kids and not the 3rd. And then make sure you've got your property listed in a trust so you can avoid an ultimate probate when the second spouse dies. But more importantly, we all like to save money in taxes. And if you have it inside of your trust, you get a second step up in basis. And what that means is that when you buy property, you have what you pay for it is called the basis in it. If you have it inside of your trust, when you pass, it's going to be looked at as the value as of the date of your death, and all of the capital gains from the basis, which is what you bought it for, till date of death, are non-taxable. They're all forgiven. So that's a big tax advantage. Okay. So I'm going to give you the highlights of why trust planning is really important. Probate is the worst. You've got some judge telling you how your assets are going to be distributed, when they're going to be distributed, who's going to be the guardian or conservator of your child, when they're going to have money, when they're not. It's all a matter of public record. No disability planning inside of it. And if you have anything that you want that is specific, that is near and dear to your heart, it might not go where you want it because it's going to be decided either by the judge or by your state probate law. So you don't want to lose control. You want to make sure that you take control. Okay, next slide. Okay, will planning. People ask, well, I've got a will. Will means probate. End of story. It just identifies who you want to have things. Names a personal representative who's going to be like a trustee, the person that manages and administers the estate. It can name a guardian for your minor child, or right off the bat, that tips off the court. We have got to have a guardianship or conservatorship hearing if your child has disabilities, and then court, again, takes control. But they will listen to the nomination. They are required to listen to it. They don't have to follow it, but they do have to listen to it. They will determine when those children get any assets or funds and how they'll receive it. Again, we're looking at a couple of years now to get in and through probate court if you've got a relatively easy matter. And the cost, think of on a $1 million estate, the cost is about $50,000. And that's because they look at the income, assets, and liabilities. And so it makes it probably, if you looked at the whole thing all in, you're probably somewhere between 8 and 26% of your estate goes to the attorney, the probate court, and to the personal representative. So it is it is really expensive.
Susan, it's Judy.
Hi.
One of our attendees, Stan, had a question. He said, if you have a revocable living trust, why do you need a will?
So the reason, that's a great question. The reason that you would have a will is because sometimes you don't put things inside of your trust, you forget. And so what happens is, look, let me give you an example. You are going to refinance your house. The lender requires you to take the house outside of the trust. They're going to go ahead and put it back in and fund it. And what they did in my case, they put the deeds backwards. So the deed took my house into the out of the trust, put it into the trust, and then took it out of the trust again. So had I passed, my house would have had to go through probate. So the will acts as a catch-all. You have to probate the asset, but then it pours over into your trust, so it goes where you want. So the wills that are associated with trusts are pour-over wills. So it's your final catch-all. So in case of something slips through the cracks, beneficiary designation ends up with a lot of retirement plans will end up as estate of. So it will go to the estate, and then it will go through a probate. So that's why you have a will. This is just a chart that kind of compares the wills and the trusts. Again, privacy of the trust, matter of public record. So if Judy filed a probate, I would be able to go in and learn everything about her, Dennis, and Josh, but it's probably already my file, so I wouldn't be going around and doing that. But, you know, but you do get, we get calls all the time. As soon as we file a probate, they're asking if we want the house to be sold. Their question is if there's anything that they can help. Investment advisors and realtors are probably the biggest. You know, and you really don't want your child's personal information, address listed on there, date of birth, whether they're a minor, listed on there. A will has no predator-creditor collection, and the biggest thing is no disability. A will does not take effect until you die, whereas a trust, you do have disability planning inside of there, and nowadays that's really critical. Most importantly, you want to have access to the funds for your family when you die. You don't want to wait for the court to decide when you can get that. Okay. So now we're getting to the good stuff. So if your child with special needs or a disability has capacity, I encourage you to have them do power of attorney for healthcare, HIPAA, and power of attorney for financial management. And oftentimes I have parents come in when their kids are, 18, 20s, and they're asking me, conservatorship, or what do we do? And I would suggest that you err on the side of caution and give them the benefit of the doubt. Go talk to the doctor, see if the doctor feels that that beneficiary has the capacity to understand the documents. You don't have to have the same capacity to do power of attorneys and HIPAA that you do to go ahead and buy a car or rent an apartment. So it's far less capacity. In most cases, you'll find that a lot of them probably do have the capacity, safer because you can accomplish the same things with those 3 documents that you could with a conservatorship. And then you don't have that stigma that's sometimes attached, because when they are conserved, then they've got some limitations. If they don't have capacity, then you do want to look at a conservatorship and a special needs trust. Again, things that happened during this COVID, we saw where adult children didn't have documents in place. They didn't have a conservatorship in place, and parents are kind of stuck, so we're running around like chickens with our head cut off to try and assist them. But it's scary, it's really scary, because regional center is the one that has the authority when your child becomes an adult to make medical decisions for them, not you. So, if you can't go ahead and get the advanced healthcare directive in place, and they've got some very, very simple ones out there for individuals with disabilities that are great to use, and you should look at getting a conservatorship. I think we've already went through most of these. Again, create your estate plan, get time to get your stuff in order. Now that some of you might be off of work, it's probably a good time to start writing this out, you know, your lists of honeydews. Put together that special needs trust. You really want to make sure that you've got protection in place for your child. We do probably 15, 20 a year where the parent just never got around to it. And so we're creating what Judy talked about was the first party special needs trust, which was when the beneficiary has their own money. They receive an inheritance. In Josh's case, it was his bar mitzvah money. They receive a settlement from a lawsuit. We have to put that in a federal type of trust. Very, very restrictive, useful, but still very restrictive on what you can go ahead and do. And if the child doesn't have capacity, then it's under court supervision, very much like a guardianship would be, where you're always in court and they're checking on the finances, they're checking on everything that has to do with the child's well-being, whether they're a minor child or an adult child. So I think that would be something you do want to give a lot of consideration to. Again, make the determination. Conservatorship, do you want to test those other avenues with the powers of attorney and the HIPAA? Look at your eligibility for benefits. Where does it fit into the lifestyle that you envision for your child in the future? Create that memorandum of intent. Again, if you don't have one, we'll go ahead and send you some samples. Okay, so Nena.
Hello, everybody. Good evening. I'm Nena Sheldon. I'm Susan's associate attorney, and I'll talk to you about conservatorships. So like Susan had mentioned earlier in the PowerPoint, it's been a pretty difficult and scary moment with this COVID going on when there hasn't been any planning involved. And so when certain medical decisions have to be made, we have to go into the court on an emergency basis, what's referred to as going in for like a temporary conservatorship to get those done. So they could be very, very nerve-wracking to get done, especially when you're trying to get decisions made as soon as possible. So a lot of times the cases that we do get in the office, you know, we get the question, you know, when should these conservatorships be established? You know, should we file it now? Should we file it later? Conservatorships, they are for adult individuals. They can be filed prior to the individual turning 18 years old. And sometimes we run into families who they come to us and their child is in their late 20s, early 30s, and they've had good luck and they've been able to get by without having a conservatorship. But we certainly don't recommend waiting for something to happen where you need that right away, because you might find yourself having to go in for an emergency or a temporary conservatorship, because oftentimes, you know, your family, your child has had established relationship with that with the medical care providers, and there could be a change in that, and so you might have some doctor or nurse that says, you know what, we need to have some conservatorship paperwork in order for us to continue to care for your child. And you certainly don't want to find yourself in that position. So what's a conservatorship? It's essentially a protective court proceeding. The court appoints a conservator. They're considered a court-appointed fiduciary. Oftentimes, like for our situation here, the appointed conservator would be the parent of the child. The conservatee, who needs the managed care, would be considered the conservatee. Essentially, what the conservatorship does is that it allows to provide the care that the conservatee needs in the least restrictive manner. So while your child may have no capacity to make certain decisions, the court does not want to take away all of those conservatee's rights. They want to go ahead and have that conservatee have the ability to act on his or her own behalf, while the conservator is able to manage other things that the conservatee is not able to handle. There's two types of conservatorships. They're categorized as a conservatorship over the person or a conservatorship of the estate. I'll touch upon the estate portion first. What Susan had mentioned was during the planning process, and your child receives money of his or her own, like a settlement, inheritance, funds from a bar mitzvah, and there's no first party special needs trust that has been established. And so what would happen is that those funds would be going into the conservatorship estate. Why that would be established, because your child would not be able to manage his or her own financial resources. They may be subject to fraud or undue influence. We do have quite a few clients at the office where you meet them and they're very nice, polite individuals. You would never guess that there was any disabilities there. But some of them, they do have like a traumatic brain injury, and so people could come up to them and then ask them, hey, can you write me a check for my gardener over here? And those things do happen. So you will definitely want to get these conservatorships of the estates established in order to protect them from being taken advantage of. A very common conservatorship that gets established is the conservatorship of the person. Oftentimes we have parents contact our office because their child is about to turn 18, is an adult, and the medical office, the doctor, are requiring court authority in order to continue to provide care for the son or daughter. So the conservatorship of the person would be established to make sure that your child's needs are properly met. Your child is not able to provide for his physical health, medical care, food, clothing, where this person would be able to live. And then there's three types of conservatorships, really focusing mostly here on limited conservatorships, which are reserved for individuals who have a developmental disability. So there are general conservatorships, like I said, the limited conservatorship, and the LPS conservatorship. With the general conservatorship, typically those conservatorships are reserved for individuals who who do not have capacity later on in life. The most common example is someone is driving a car, they get into an accident, they no longer have capacity, and so medical decisions have to be made, or financial decisions have to be made on behalf of that individual, and so a general conservatorship would be established. Then we have the LPS conservatorships, and these are typically referred to as these mental health conservatorships, which involve individuals who have serious mental health disorders such as schizophrenia, bipolar disorder, clinical depression, those types of mental health disorders. And with the limited conservatorship, with these types, they reserve some powers for the person with a disability, your child, and transfers other powers to the parent or the conservator. So in general, the limited conservatorships, they are a protective proceeding in order for those individuals with the developmental disabilities, in order to be able to care for themselves and their property. They are only used when it's necessary to protect their well-being. We get comments or questions oftentimes from some families where, okay, my child doesn't have the capacity, we need to get a conservatorship in place, and they want to be able to control every aspect of that child. And so how the courts operate, they typically will only grant those powers that are necessary to promote and protect the well-being of that individual. So they will only go ahead and provide those powers in order to promote that disabled individual's individuality and promote them being able to make decisions on their own. Okay. So limited conservatorships, like mentioned earlier, they are reserved for individuals with developmental disabilities. The probate code section, they do define what that is. And they require that the disability, it originates before the individual reaches the age of 18, and that disability is expected to continue indefinitely, and it constitutes a substantial handicap. The definition specifically includes those individuals that have intellectual disabilities, cerebral palsy, epilepsy, and autism. It, however, does not include those individuals that are limited solely to physical handicaps. Okay. And it's important to note that limited conservatees, they're not presumed to be incompetent. They are afforded with all the legal rights and civil rights, except that the court grants to the limited conservators, the parents. The limited conservator, they're able to oversee the care, the custody, and control of the conservatee, subject to the limitations ordered by the court. Like I said, the court, they're not going to grant all of the powers that are available unless it is absolutely necessary. So the responsibilities of the limited conservator is really to assist the conservatee to become self-reliant, self-sufficient, and independent by making sure the individual has the appropriate treatment, training, education, medical, psychological services, social opportunities, and just making sure that conservatee's functional abilities are provided in the least restrictive manner. And so these here are what we call the standard 5 powers that the court will typically grant the conservator. And these powers are involved the ability to select where the conservatee is going to live, having access to the confidential records of the conservatee, controlling the conservative's right to enter into contracts. The most common one that usually is the reason why clients, they will go ahead and contact our office is because they need to be able to manage the medical care for the conservatee, and also making decisions for the education of the conservatee. There are 2 other powers that are available, which is the ability to control the conservatee's ability to enter into a marriage and to control his or her sexual and social contacts. For purposes of Orange County, it is extremely difficult in order to get these 2 seldomly granted powers granted, just because Orange County, they typically require some sort of imminent danger, which would merit the court to grant these powers. If you're in LA, the Los Angeles Superior Court, they're a little bit more lenient in granting those 2 additional powers, but for Orange County, you have to show the court that there was some situation, for example, that had happened previously where it would really warrant this type of power to be granted to the conservator. Again, because the courts are very hesitant to provide these powers to the conservator and not leaving any of these powers to the conservatee, because they want to be able to promote the conservatee ability to make these decisions in the least restrictive manner. Okay. And so how's a conservatorship established? First, a petition for appointment for the conservator has to be filed with the court. Prior to the COVID-19 epidemic, Orange County, they were running about 14 weeks out from the date that you file the petition. Our office just recently filed a conservatorship petition, I believe it was May 8th, and we have a hearing date set for September 1st. So it's taking about 16 weeks. Now, because there's new restrictions and the county's coming up and the state's coming out with new orders, the timeframes are constantly changing. So we're constantly monitoring the court to see if they have any new deadlines out in place, but recently it looks like it's about 16 weeks. So it may turn out that it could be a little bit longer. So we'll see. The proposed conservatee, your child, they are required to attend the hearing unless a doctor certifies that, you know, he or she's not able to attend the hearing for specific medical reasons. You know, we have cases where the conservatee is in a facility, is bedridden, non-communicative, so physically this individual is not able to go to the court. And so we'll go ahead and assist the family with preparing the documentation and coordinating with the primary care provider to have the necessary documents completed and filed with the court in order to excuse the appearance by the conservatee. As I earlier mentioned, the petition for the conservatorship can be filed shortly before the 18th birthday or anytime afterwards. But again, we don't recommend waiting because oftentimes when we wait, something happens and you'll need that, that ability to make those medical or financial decisions right away. And oftentimes, if there is an emergency, the doctors will treat. But if there's no conservatorship in place and your child goes to see a doctor and there's an elective procedure that needs to be scheduled or to go ahead and get completed, that can't be done until a conservatorship's in place. And if you're in Orange County, you'll be waiting about 16 weeks to get that authority from the court. That allows you to do that. The fees and costs involved to establish the conservatorship, they will involve attorney's fees. Those will vary because whenever you're dealing with the court, there's a lot of unknown variables involved because in the event there's any perhaps maybe contention within the family, there could be a possible objection filed, or if a temporary conservatorship is required, because that does require additional hearings that the attorney must appear for, and additional pleadings that have to be prepared and filed. There are small laundry list of costs involved with the establishment of the conservatorship. You have the petition filing, there's the court reporter fees, the court investigator fees, there's the parking fees, attorney service fees, the fees in order to obtain the letters for the conservatorship. And the letters are the conservator's golden ticket, if you will, that the conservator will be able to show the medical providers that they do have the authority to make these decisions on behalf of the conservatee.
Nina, I had a question from one of our members. So Shannon wanted to know, once a limited conservatorship is approved by the court, how long is it effective?
The limited conservatorship of the person is effective. Once it's approved, it's effective until you terminate those proceedings. What happens is that once it's approved, the letters will issue, and the court investigator, they will go ahead and make periodic visits with the conservatee and the conservatee's family just to check in to see how the conservatee is doing, if indeed that this conservatorship is still, you know, necessary.
Thank you.
You're welcome. And so prior to the hearing, what happens is that the court will appoint a court investigator. to interview the proposed conservatee, as I had just explained. They'll interview also the individual who's petitioning the court, and as well as the proposed conservator. Oftentimes the petitioner, that's the individual who is filing the petition, it's oftentimes the same person who's the proposed conservator. So for example, we have parents who come to our office and they let us know that, okay, my child needs a conservatorship. And so we'll go ahead and prepare the petition. It's the parents who are filing the petition. And in that petition, we're asking the court to appoint the parent as the conservator. And so once the court investigator visits all of these parties, then they will go ahead and prepare a report and submit that to the court with their findings as to if they support the petition, essentially, and any other concerns that the court investigator may have. Also, the court will appoint an attorney for the proposed conservatee to represent the conservatee, because again, the conservatee does not have the capacity to voice his or her feelings about the conservatorship. And so the court wants to make sure that the conservatee's rights are adequately represented. In Orange County, what the court does is they appoint typically the public defender to represent the conservatee. Whereas in different courts, such as LA, they will actually appoint an actual attorney to represent the conservatee. Regional center is also involved, especially when the conservatee is receiving services from regional center or has received services from the regional center. So they will be receiving notice, and during the process, they also prepare a report, which is also filed in the proceedings. And so when it comes to the hearing, the petitioner, the proposed conservatee, if the conservatee is able to attend, and the proposed conservators are going to be in attendance at the hearing. If the conservatee is present at the hearing, the court will ask the conservatee's opinion as to what he or she thinks about the conservatorship, and if he or she is in support of that. Most often, the individual is, because when we are in the process of preparing when our office is in the process of preparing the conservatorship petitions, we do like to make sure that the conservatee, is involved, is on board with what's going on. If there's other family members who are on board or not on board, just so we can anticipate any possible issues that may arise along the process. And so if in the event the conservatee does object to the conservatorship, then what the court does is usually they'll continue the hearing and set a trial to go ahead and get the issues resolved. Hopefully they get resolved before trial, and a trial will not be necessary. And at the hearing, the court really scrutinizes whether or not the proposed conservatorship is really necessary and in the best interest of the conservatee, because not every developmentally disabled individual does require a conservatorship. What we oftentimes see at these hearings is, as the court is granting the standard 5 powers we had looked at earlier, one aspect that the court doesn't like to take away is the voting rights of the conservatee. So as much as possible with these limited conservatorships, they want to reserve as much rights as reasonably possible for the conservatee. So really the conservatorship depends upon that individual's functional abilities, his or her needs, and really the capacity level to be able to care for him or herself, like a reasonable person will be able to do so. And at the end of the day, the conservatorship is really there to promote the well-being of that individual, and really to encourage that individual's independence and self-reliance. And so Susan and I have provided here some helpful resources for everybody to refer to. And as Judy had mentioned early on in the presentation, I believe she has made these available via email, and I believe you could download the links to this PowerPoint and have access to these websites. And we thank you all very much, and if there's any questions, we're more than happy to address them.
I wanted to just point out, thank you so much, Susan and Nina. So if you have any questions, please use the chat function to let us know what you're wondering. I wanted to point out, if you go back to your slide, Nina, I wanted to point out that that you had a link to the Disability Rights of California, and that is the group that's coming to speak in June. So happened independently, so thank you.
We like to promote each other.
Okay, Shannon wants to know if this is being recorded, and the answer is yes. So I will send you all a link in a day or so. Deborah asks, can you put retirement accounts in a trust?
Okay, you can, and it depends upon what type of trust. So last December, the Internal Revenue came out with what's called the Secure Act. So they really created a can of worms regarding retirement planning. So for the most part, you are going to have a 10-year payout on retirement plans when somebody dies, and the exceptions would be spouse gets a rollover, so they don't have to go ahead and take it out in 10 years. Child with a disability, they don't have to take it out within 10 years as long as their trust is properly drafted. And then chronically or terminally ill people will have the same, they don't have to take it out in 10 years. So yes, you can. For your revocable living trust, you are going to have some different rules than what you have for the special needs trust. For a special needs trust, you're going to need to have that trust act as an accumulation trust, which accumulates the retirement benefits and doesn't have to distribute them, because you can imagine if it would act as a conduit and that money comes out and automatically goes and pays to the child, you're going to have benefits issues. But yes, putting a retirement fund, having it as a designated beneficiary special needs trust is a great idea. Definitely a great idea. A little bit more complicated now with regular trust, but we're looking, so I would suspect that what you're going to see is a lot of individual retirement accounts, but they aren't going to have the final regulations out on the Secure Act until sometime in the fall. And I'm not sure now with COVID if that's going to be pushed back, because they've been throwing little pieces out in cleaning up some of what does this mean, what is the definition of disability. Is it the state law definition? What is the definition of an adult? Because minor children are exempted as well, but is 18 the age, or is 21? Some states have a age of majority of 21. So we're hoping to get better guidance by 2021.
Susan, I'm going to just add a personal experience there. So Betsy left Josh what was her 401k, although she was a government employee, so it's a different type of account. But so that's in Josh's trust, and so he gets an annual distribution from that. And then Susan sent you some information on ABLE accounts, and it's within the amount. We take 15K of that and put that into his ABLE account. So that's kind of how we feed his ABLE account every year. But that was done with her retirement fund. Let's see, a next question here. Oh my goodness, we've gotten a lot, Susan, so you're not going to be bored. If a parent has power of attorney over the adult child with limited conservatorship, be better to have? It's kind of, I think, which would be better. If a parent has adult power of attorney over their adult child, would that be better than a limited conservatorship?
You know, it would really, I would be curious to see that written power of attorney, if it does provide all of the powers for the parent to make certain decisions, like, like the healthcare, being able to fix the residence of that individual, similar to like the powers that you would be able to obtain from the court, but depending on how that document was drafted, and what powers are afforded, you might have to be able to go into court to obtain additional powers. For example, I know that we were just looking at a conservatorship and determining what if a conservatorship of the person needs to be established, and there is a power of attorney in place. And so we were looking at that to make sure, okay, this individual has the power to make the healthcare decisions. Do they have the power to go ahead and decide where this person is going to live, because the individual was living in a facility? So in case that facility doesn't work out anymore, can this person be moved? So I believe it might really depend on what's in that particular document, what authority that provides.
I think too, you want to look at the individual, because the powers of attorney are great. However, if they're subject to undue influence and maybe a little bit more difficult to handle, just imagine somebody coming in and saying, you don't need that, get rid of your parents, put me on, because we see that a lot with elders. They've got their financial powers of attorney, their medical powers of attorney, and all of a sudden they come up with some stranger is going to go ahead and assist them. And that's what you don't want. But again, conservatorships can be a little bit more restrictive. You can get kids out of, they went in and bought a car. You can get them out of the contract with the conservatorship. You can get them out of, the apartment that they rented or some of the things that they do. But it is a little bit more limiting. So I think it's like, know your child and, talk to an attorney and explain to them, share with them, this is my child. Do you have a feeling for this? And again, it's, what is their financial literacy? Do they understand, or are they subject to undue influences? Do you need just the medical power, which might be, the only thing that you would have to go ahead and have, and that way you can trump everybody. Just my 2 cents.
Thanks, Susan. This could either be Nena or Susan. Is 16 too young to start applying for a limited conservatorship?
Yes, it would be. The timing of filing the petition, just because there is that lag time between when you file and when you get the hearing date, probably would be recommended so that by the time you file, you would get a hearing date maybe perhaps like a month before the 18th birthday. We did have a situation, actually it was in LA, where before then it was fine to go ahead and file, and you have your hearing date 3-4 months before the 18th birthday. But there's just been some changes in that court where the court had required, okay, let's continue the hearing, let's have this a little bit closer to the birthday. So they continued it, I believe it was like 3 weeks before the birthday. So.
Okay, thanks, Nena. So Susan, this comes from Martin. He says, I'm a beginner on this topic. I do not have a will. I'm divorced and have 2 kids, and only one has special needs. How would you recommend creating a legal doc for both kids at once, will and S&T?
It's a good question, Martin. And right now, the only thing that you would be able to do would be create a revocable trust. How old are you? And without knowing the age of your children, I'm going to assume that they're minors. Would be create a revocable living trust, make the trust for your non-special needs child have specific support provisions in there that you can pay for health, education, maintenance, and support of that child. And with the other child, you would be looking at limiting it to comfort, welfare, happiness, because health, education, maintenance, and support will go ahead and exclude them or disqualify them from government benefits. So you have to be very specific on the language. You could put it in one document. It wouldn't be something I would live with forever, but as a temporary fix, I think it would be okay. There are multiple problems with a trust inside of a trust, or we call them subtrusts. So think of your child with special needs. That trust doesn't come into existence until you are deceased, because your trust document is going to say, on my death, my assets are going to go to 1/2 to Sally's special needs trust, which is going to pop into place. And so nobody's going to be able to contribute during lifetime. But as a temporary solution, that would probably work. But I'd look at the long haul that you want to go ahead and definitely have something in place for your other child. And again, you'll have some issues with retirement planning, because while the children are both minors, you're probably okay, but anybody else becomes involved in there, or when one of them becomes an adult, then you've got a whole nother can of worms, because very, very specific things that did not exist before with the retirement planning for individuals with disabilities. Same thing with minors. So it's conducive to them for a while, then it's not conducive to the rest of the people when you create the certain types of trust. So you have to think about, long-term, how are we going to go ahead and best achieve things long-term? Right now, it would probably be to do separate trusts, but for temporary, you could put it both in one. You just have to separate the distribution standards into comfort, happiness, well-being. So.
Okay. Thanks, Susan. This question comes from Julie, and she asks if there are any advantages or cons in putting money into an ABLE account versus a special needs trust.
Well, the two of them really should go hand in hand. So the cons of putting it into an ABLE account, and I think ABLE accounts are fantastic to go ahead and teach independence and financial literacy and give somebody some self-esteem and be able to guide them through, a budget. I think Regional Center actually works with them on helping them be financially sufficient. The problem is that cap, $15,000 a year, that's what goes in. If you put $15,000 in January, there is nothing to say that they aren't going to meet somebody, be subject to undue influence. And by February, you aren't going to have 50 cents left. I think Josh might have got into his ABLE account at one time and bought Yu-Gi-Oh cards.
Yeah, and then we told him that he had to use cash for that.
Yeah. So, it's the ABLE account is got good structure, but it should be for the purposes of teaching some financial literacy, budgeting. So you can only have $100,000 that you would put in at the max, and it has to go in $15,000 a year, and then you lose the SSI. Medi-Cal is a little bit over $300,000 in California, but again, there is no limitations. That child or that individual manages that money unless they are conserved. So they manage it, they can take it out whenever. So there are some restrictions or penalties if you take the money out for non-qualified disability expenses, which is a pretty broad term under the Internal Revenue definition. But again, I think that the best thing is that you use them together. I know Judy has used both of them together, and they seem to work. They seem to work pretty well. She had things auto paid. Josh had a TrueLink card, and he was able to use that for certain things, right?
Yeah, I mean, let me kind of explain. I think it's like playing a Milton Bradley game. You get better at it the longer you play. And what I found the Able account was good for is paying for things like rent, things like that, that that need to be paid. You know, when you're paying for rent, it's something that Social Security wants that paid for by the individual versus by a trust, because then it's kind of assistance, right, Susan? It's kind of
Yes.
So
Income.
So it's income. So if you can pay for things out of the Able account that you don't want treated as income or, you know, assistance, financial assistance to your child, it's a strategy. So like when Josh was in the dorms, we had the dorms be paid for out of the Able account. Now the money that you can have, a parent can have control over the Able account because you basically are set up as a representative payee, and so you can control that money as well and make payments from it. And so when we paid for the dorm, we paid for, you know, writing a check out of the Able account. So you can have control over it. You don't necessarily have to give all the the power to your child, although you can if you so choose, because they do have a debit card and you can use it that way. The other thing is with the Able account, if your child is working, they can have their salary it doesn't automatically get deposited in. You have to do take the paycheck and then write that amount and move it into the Able account. But what that allows is the accumulation of wealth up to the 100K beyond the 15K max that you can deposit into your Able account as a place to store money to keep them eligible for government benefits. So that's another advantage of an Able account that's not even in the realm of, well, I guess you may be able to do it with a special needs trust, but it seems very complicated. So that's something else to consider. But the Able account gives you a lot of flexibility. It's kind of like your change purse versus, you know, your bank account. You know, the trust can have access, but you know, you may want to use that money differently. I hope that helped. Okay, Susan, I'm going to go on to the next one.
Okay.
Let's see. What is more limiting, a special needs trust or a conservatorship?
Conservatorship, wouldn't you say, Nena? I think a conservatorship takes away rights. A special needs trust, you're really promoting more opportunities for them. And the assets in a conservatorship are considered resources for government benefit purposes.
Yeah, because we'll get those conservatorship of the states established typically when the conservatee is not receiving the needs-based benefits, and it's not intended that he or she's going to try to qualify for it in the future. And yeah, usually with the conservatorship estates, they're pretty restrictive, whereas versus the special needs trust, while those are some of those are under court supervision, the court is more lenient on certain things you can do with it. they're less inclined to for certain expenditures to go out with the conservatorship estates.
Thanks, Nena. This next question is from Deborah. What is the approximate cost to create a special needs trust?
So from what I saw, I listened to a couple of webinars, you know, when you sit home because you're working remote, you do things that you wouldn't normally do. So it seems that special needs trusts are starting at about 3,000, 3,500, 4,500, right around in that area. And it was a pretty broad range, but there's a lot of planning with that. So I think that you're probably, 3,500, 4,000 is what you're probably really looking at to put together something. You want to look at it as really a lifetime document. It's far more than just what is the words on the paper. You want to, get your paper and put it inside of the book and life is good, but you really want to work with your attorney on, what is my plan? How do I get there? I like to ask my clients, I want to see budgets. I want to hear about this. I want to know about that. Where's your memorandum of intent? I want to look at it. You want me to correct it? That's how we have some that we've redacted, but it's really important to make it a life plan, because if you don't do anything with it, it's nothing more than words on paper. So, you really want to learn and take advantage of the opportunity to build the best system for your child that there is. And you've got all of the knowledge about your child, so you're a wealth of information for that attorney, and then the attorney will share with you how to go ahead and structure things so that when you combine your efforts, you're going to come up with something that's going to be great. Because really, which one is peace of mind, knowing that you've done everything to provide for your child? It's not an easy topic to go ahead and talk about. So walking out knowing that you've done it all and you're off to a good start. You're going to be updating your memorandum of intent every year. You're looking at budgeting. You're working on financial literacy. It's great. And now you've got your people that are your trustees and the rest of the appointees, the trust advisory committee, the trust protector. You can give them a little bit of an education on, this is what I learned, this is what my expectations are, this is the goal for my child.
Thanks, Susan.
We do those in the office. I like to look at them like, if you're going to leave your child with, a caregiver, or little child with a babysitter, you're not just going to leave your child with a caregiver or babysitter without any instructions. You want to make sure that, this individual you're leaving, your loved one being cared for, that they understand what, his or her unique needs are, what they like, what they don't like. So I always kind of like to look at it that way as well.
I want to add, we have a memorandum of intent, and I just updated it today.
Nice, I'm proud of you.
And the reason I updated it today, it has a directory of all our friends, it has all the go-to people, it has the accounts, and Josh is in the process of qualifying for Medicare, and so I just got the Medicare number, so I added that to the memorandum of intent. My intention, we updated our special needs trust in the last year or so, and that was because all the people that were going to be our go-to people seem to be aging. I don't know why. And so we chose to, we found a fiduciary to be the trustee after Dennis and I are gone. And my intent is to start an annual meeting with the collective group of people so that they could start meeting. But it's not just for them, it's for Josh too, because especially with COVID and stuff, these kids, are very sensitive, and they worry about our livelihood, and they're worried that if we're gone, are they going to be able to take care of everything? And I don't think he fully understands that there's a team behind him that's going to support him. And I think that inviting him to the annual meetings, or maybe we'll do it twice a year. We have, I've been kind of like waiting to start it till the accountant would be done with taxes, and they keep on extending how long it is that taxes could be done this year. But, my intention is to have this group meet, and so then Josh can meet, and Josh will know who the team is, and he'll feel more secure knowing that it's the rabbi and it's a psychologist and it's, you know, the people that he, you know, my brother and the people that he knows. So that kind of adds on to what Susan was talking about the team. That said, the next thing is a question from Denise. It's probably for Nena. What kind of documentation helps to support a limited conservatorship for an adult child with mental issues like PTSD, ADHD, and autism? IEPs, psychiatrist letters, neuropsychologist evaluations, etc.
All of that. All of that. Yeah, because when we're gathering all of the documentation information, preparing the petition, of course, we want to give it, you know, its best shot to get approved, be able to provide enough information so that the court doesn't have any lingering questions that would result in delaying the proceedings. So with the limited conservatorships, the parents oftentimes have access to them. Regional center reports, IEPs, any types of medical reports that have been generated by their medical providers. Just any type of written documentation that describes, you know, the needs of the individual, what the disability is, and anything to really support why the conservatorship is necessary for the child.
So keep in mind that the powers are going to probably be limited to the typical 5, so it won't include any ability for putting them inside of a facility or keeping them in a facility, forcing them to take any medications. That then falls with the LPS conservatorship. And you really don't get to bring your own LPS conservatorship when they go on a 5150 hold is when you need to talk to the doctor. I find that, especially with COVID, they've just been out the door, out the door, out the door. But even before, you couldn't get them to go ahead and really do anything. It took some horrible or egregious or really something stupid before they ever took notice and did something. You know, it was either somebody committed a crime, they were going to be incarcerated, they ended up having to go to into a program, and the program helped her. They were so negligent with a minor child that they, you know, not only did they go ahead and do an LPS conservatorship, but then they also took away parental rights. But I think that, you know, going to NAMI is also a great opportunity. I mean, they really do provide a lot of support if they have mental issues, to, you know, different classes that you can have and people to talk to when things happen.
Susan, since the camera's on you, the next question is, how long does it take to put them, I think this is a special needs trust, in place? Do power of attorneys need to be notarized, and how does that work with COVID?
So so trusts take a little bit longer. So usually we meet for a couple of hours to fill out a questionnaire. We meet for a couple of hours. I draw it on the board because I want you to see exactly how it works and where all the pieces of the puzzle fit together, so you can decide. I'm very big on customization because no two children are the same. You really want to deal with the uniqueness of your child, what your family situation is, what your goals are, what your beliefs are, so that, you know, it's like life is normal. Once you get it all in place, it just kind of moves along and it's good. Powers of attorney, they are quick to put in place. Sometimes when we're dealing with adult children, we'll just talk to them on the telephone if we know the family or know them. And what we've been doing for notaries is we actually got single strip, one-time use ink pads. It's actually what they use for doing fingerprinting for children. And we got that so that then we do any type of notarization outside on a table in our patio area by our office. They've got mobile notaries. They have, UPS store typically has notaries in it. Some banks will have notaries as well, but we've been very cautious about doing it outside like they recommended, and having everything in a more sterile type of situation. My meetings are all by Zoom, and then documents are distributed via email. So
I'm going to add
something we just kind of deal with this situation now.
I'm going to add on to Susan. It takes a little while to put together a special needs trust. The questionnaire, it's easy for Susan to say that that's one word for her, but for the person filling it out, there's a lot of information you've got to pull together. So, and in a sense, you're putting together your own. If you don't have your own family trust, you're going to end up probably doing that as well. So plan on it taking several months. It's a project for the year, it's not something. I know Susan has done emergency situations where she's had to do it very, very quickly, but you guys it's probably going to take you a bit of time. I had a couple questions about ABLE accounts, so let's take those now. Will money in the ABLE account prohibit my child from getting SSI? Want to take that, Susan?
Sure. No. When they established the ABLE account, it was specifically to allow individuals that had disabilities that were receiving needs-based government benefits with the opportunity to accumulate some funds, some wealth, and follow within, instead of being able to have $2,000, now for SSI you can have $100,000 in there. So it doesn't disqualify you at all. In fact, you can use as Judy was alluding to before, think of it this way. If the trust pays for Josh's rent, they are going to go ahead and take 1/3 the federal benefit rate, or what I think it's $773, what everybody in every state that's receiving SSI could get for payment. They're going to take 1/3 of that. It's $270 some bucks that they take off plus 20, because Josh's trust is paying for it. If instead Josh takes part of his SSI, takes part of the money from ABLE, pays the rent, there is no reduction. So he gets the full $973.42 versus $600 and some dollars a month. So you save actually about $3,600. So the good thing is the Internal Revenue Service monitors the ABLE account, and they've given qualified disabilities a very broad definition. They have really overseen what SSI can do, because SSI can be quite punitive and relentless when they deal with things. So no, it's a great thing. It is absolutely a wonderful thing.
Yeah, and I'm going to add a little bit more to that, which is, so, we've been doing all this for 10 years. And one of the things we didn't realize is when you apply for SSI and you get approved, they give you a big check, and the check goes back to those monthly payments from the time when you applied. So you could get, and it takes 10 months to get approved. So you could get about 10 months worth of payments, which could be, thousands of dollars. And now all of a sudden you need to worry about being at that $2,000 level to qualify for SSI. And I misunderstood how long we had to spend that down. They give you some time to spend it down. I thought we had 2 years. I think we had a year. And so Social Security watches that money, and they said, guess what? You have too much money. You're going to have, you were disqualified from receiving SSI for the following N months. And you get a letter like that and you freak out. So, you know, and then what they do, what you find out is that they'll negotiate with you and you can have a payback period and all that, and everything will be okay. But my point being that having that ABLE account and having a tool to bring down how much assets your child is holding is a really important tool that you need. And so if they're working or something like that, having that available is good. And if they're paying rent, having a way to pay it and not have them lose a benefit is a good thing. The other thing is it's really easy to apply. It's not cumbersome at all. You can do it in like 15 minutes. So it's definitely something you should do, can do, easily do. They don't ask for your medical records or any kind of proof. You know, it's just saying, yes, it's just a click-through agreement saying, yeah, that this is true. This child has this disability, or this person has this disability. So anyway.
I think it took me about 6 or 8, maybe longer, 9 months to get you convinced to go ahead and do one.
No, I did it right away, Susan. I heard you talking about it and boom. I was like the first one on the block.
You were.
I know. Okay, next question. Can someone have, this is from Sivag, in Santa Monica, yay, Santa Monica, where I was born, can someone have an ABLE account and a special needs account together? I'll give that one to Susan.
Yes, actually it's the best way to work, because what you've got is specific instructions inside of the special needs trust that you want. You also want your child, if they have some capacity, and even if they've got limited capacity, where you do have a conservatorship, but they go out and do things, you want them to have access to a little bit of fun so they learn some independence, so they can stand on their own and, you know, do some self-advocacy as well. So, you know, it's wonderful when they can say, I'm going to go to the movies with my friends, and they can actually go pay for themselves, despite the fact that all the parents are driving them and picking them up. That little bit of independence is a real self-esteem builder. Some of them are very interested in learning how to do the investments with inside of it. So again, they both have different qualities. They're the beneficiary, or your child is not going to be the trustee of the special needs trust. They are going to be the beneficiary. They don't manage the money in there, the trustee does, whereas they can manage the money or be given a TrueLink card to have access to some inside of the ABLE account. So coordination is the best part of both accounts.
Thanks, Susan. Okay, Denise's husband wants to know if only natural persons can be named in a trust. He's thinking of a corporations could be named and wonders if it lives forever. So I guess there's two questions. One, can you name a corporation as the trustee? And then the second is how long does a special needs trust live for?
Well, trusts don't die, and that's kind of like charities. You know, trusts really don't die. So that's when you're going to, if you want something to continue on forever, you just have to put in the right provisions and name multi-generations, my children there and their heirs at law, and it will age out or terminate when the rule against perpetuities comes into place. But the trust doesn't really ever have to terminate. It will terminate typically when the beneficiary dies. However, keep in mind that, you know, you want to look at administrative costs when you've got a trust. So if you're thinking you want a trust for 100 years, you know, the cost of administering it, just with filing, you know, tax returns, and, you know, you might have a trustee that wants money, you might be taking out insurance, would be expensive. So I guess you could go ahead and you could name a corporation as the beneficiary. You could name anybody as the beneficiary. It's and you can have Wells Fargo is trustee, Merchants Bank, a lot of the banks will act as trustees as well. So you could get some longevity. It's just a matter of what you're trying to achieve, and that's why the assets don't count, because the assets of the beneficiary, when they're held inside of the trust, they don't count because it's really for the benefit of. So hopefully that answered your question.
Yeah, I'm going to add a little bit more to that, Susan, which is we did look at having a bank be the trustee, and we personally decided against it because we felt our son really needed some. I felt like a corporation is harder for my child to deal with than a person. So I think you have it's a big decision. So you need to really, I'm not saying that you shouldn't, but it's a big decision. So you should really meet with the people, figure out how it's going to be. And there's always needs to be provisions to change that corporation out, because you need to be thinking, what are their priorities? Is it about having money to invest, and that's what they're looking at, or are they going to be thinking about the benefit of my child? So you can, but it's a big decision, and I recommend that you really, really think through who you name as the trustee. That said, next question. I think this one's for Susan. With a special needs trust, can I get my adult child out of his marriage, buying a timeshare, buying a car? Susan.
Well, I guess if they have the money to go do all of those things, we've got the problem right from the beginning. So if the special needs trust isn't going to prevent them from doing anything, just like a conservator of the person wouldn't. If you've got a conservatorship of the estate, when you have a conservatorship of the estate, there is court supervision. So the court will be monitoring what you or that child spend the money on for the remainder of that child's life. So when you have a special needs trust, you set up guidelines on what the trustee can spend money on. And of course, that changes every year. That's why you use that memorandum of intent and update it, so you can update what they can spend money on. But conservatorship won't get them out of a marriage. Special needs trust won't get them out of a marriage. Special needs trust could prevent them from buying a timeshare or a car, because the special needs trust will have all the money. If you only have a conservatorship of the person, they have money, then I guess that they'll be able to do that. I might have misread the question wrong, but did I read it wrong?
No.
Okay.
No. I think, yeah, I think one thing to add, Susan, is more, and you and I have talked about this before, is more the issue of people taking advantage of the person. You kind of alluded to it, but when those kinds of situations happen, when someone wants to take their money or have them invest in let's say Josh had somebody who wanted him to invest in their film and to use the money from the special needs trust, then there at least is somebody who can say no.
Yeah, you have to, it's a crazy world out there. Look at remember the young man somebody that you knew? His parents took the time, created the special needs trust. They were convinced by people from the church to make them as the trustees. When the second parent passed, that kid was sent on a one-way ticket to South America. They disposed of all of the assets. He wandered around there until some person took pity on him and sent him back, only for him to find out that everything was gone. The good news is he's got a great trustee. So Rob is his trustee, who you know.
Well, yeah.
And the court system got volunteers to go ahead and go after the people that stole the money, and they were charged criminally two of them, both of them went to jail. One of them's paying restitution, and it looks like they snapped. The other one was going to be getting a distribution from a trust, and they snapped or put a lien on the house that was supposed to go to them. So, but you really, that's why I said you got to really like people and trust people who want them to take care of your child, to advocate for your child. It's more than just the money. It's more about what are they going to provide for your child as far as care, protection, checks and balances, love, structure, protecting them from creditors, predators, and themselves.
Okay, thanks, Susan. This is going to be the last one, I think, because we're getting close to that witching hour. It says, this is from George. George asks, I thought SSI will be reduced if wages reach certain amount, no matter what, if you have an ABLE account or not. Am I wrong?
SSI, so wages are earned income for SSI purposes. So they will reduce it $1 for every $2 earned, and then you get a $70 credit. So if you're getting $570 from SSI, or if you earn $570, they're going to take off the $70 credit and then look at the $500 remaining, divide that by 2. So it'd be a $250 reduction from your SSI payment. So they do, and if you earn more than what the reduction ends up being, then you definitely will go ahead and lose it. But that's not a bad thing. Wasn't it? Was it your son or was it somebody else? They said, so to show you how smart it was at one of the meetings, they said, so that I guess that means that $1 for every $2, that means I'm only working for half the amount of money that they're paying me an hour. Was that one of your meetings, Judy?
I want to add to that. So George, there's 2 different ways your salary affects SSI. So Susan described how your earnings reduce your SSI benefits, which is true. But the other thing you got to worry about is if you earn money and you're not spending everything, then you're accumulating wealth. And SSI requires that you have no more than $2,000 in all your savings and checking accounts. And so what the ABLE account does is it allows you to take your earnings and place those into the ABLE account. So that way you can take your all the way up to 100% of your paycheck and put it in there, so you're allowed to save money. So let's say you want to save money for a car, you can do that and not have that impact SSI. So that's kind of the part 2 of Susan's answer. So Susan, any last comments, Susan or Nena, before we call it an evening?
If I think that on the last page, our contact information is there. If you want a form to see what's required or what you should put in a memorandum of intent, you can email me. Better to email either Stephen or Joy at the same address, Stephen at Katzen Law or Joy at Katzen Law. And we also have some redacted versions. Even if you don't have a special needs trust, I would suggest you put one together, so if something happens, that people know where you are about your child, as much information as you can provide. And I think, the COVID should have given us all a reason to pause and say, planning for the people that I love is probably the best gift that I can give them. And I need to go ahead and start getting my things in order, so I'm not creating any hurt. I'm making sure that I'm taking care of people that I do care about. So have a wonderful evening and stay safe and healthy. Nena, you have anything to add?
Yeah, I think, that's a good point. Having your memorandum of intent, start working on that. And at the very least, make sure that, you as a family, you're spending so much time, really providing that care for your child. And we sometimes forget about ourselves. And so remember that planning on the family's end, the parents' end, is extremely equally as important. So at the bare minimum, really think about getting those healthcare powers of attorney, financial powers of attorney in place, just because you just never know what might happen. And so, you know, don't want to find yourself in a situation where it's an emergency situation and it's become a more expensive situation. And it's just a lot easier when planning is done beforehand. So to make sure everybody is taken care of.
Well, thank you, Nena and Susan. It was a really informative session. I've got a lot of big thank yous on the common field here. And I want to thank everybody for attending today's session. And I wish you all a great week. And look into your emails for new activities from the Orange County Asperger's Support Group.
And happy Memorial Day, right?
Yeah.
Thanks for having us.
Yet another day.
I know. Okay, good night.
Night, everyone. Thank you. Bye.